Okay, good morning, everyone. Welcome to the Mills and Reeve People Matter webinar. We're focusing on the Employment Rights Bill today. I can see that people are still filtering in from the waiting room, but we'll make a start. We've got quite a lot to get through this morning. Thank you so much for joining. Um, and apologies to those who have been on the call for a few minutes and have heard me say this several times already. But if you would like to scan the QR codes on the screen, um, you'll see our LinkedIn profiles. And if you'd like to connect with us and see the content that we share, that would be great. So my name's Fiona Longden. I'm a solicitor in the employment team here at Mills and Reeve, and I'm joined by my colleague Samantha Sargeant today. This webinar is being recorded, and you will receive a link to the recording after we've finished. We are planning to answer questions at the end of the session, so please do put any questions that you have as we go through in the Q&A box. If you could pop your name on as well, that would be really helpful. And at the end of the webinar, when you close the session, you should receive a pop-up for a short feedback survey. And we'd be really grateful if you could please complete this because it really helps us to deliver sessions that are useful for you and understand what future topics might be of interest. So the agenda for the session today is to give you an overview of the Employment Rights Bill, the likely timetable for implementation, a focus on some of the key areas that it covers, and also looking ahead as to what might be in the pipeline. So, in terms of an overview of the bill, as published, the bill runs to around 150 pages, and much of the detail is still to be worked through with consultations and secondary legislation. But in overview, parts 1 and 2 of the bill set out the provisions on employment rights, and that's roughly a third of the bill at present, and it will be the main focus of this update. Part 3 deals with pay and conditions in particular sectors, and the main focus is establishing a negotiating body for the adult social care sector. Part 4 looks at trade unions and industrial action and covers repeal of existing legislation and also providing a framework for increasing union access to the workplace, easing rules on balloting and introducing electronic balloting, increasing protection for striking workers, and making the route to compulsory union recognition easier. We can't really assess the detail or the impact of this without the detail, in which will be in regulations. So it's likely we'll cover this in a future webinar. So part 5 of the draft bill provides a framework for establishing a single enforcement body to enforce key employment rights. This is something that's been in the pipeline for quite a long time. It was one of the key recommendations from the Taylor report, which was published in July 2017. And for completeness, Part 6 deals with general provisions such as commencement, territorial scope. Most of the measures extend to Great Britain only. So, looking at the timetable, as you'll have heard, the Employment Rights Bill was presented to Parliament on the 10th of October. It received its second reading this week on the 21st, and this was accompanied by a flurry of related documents. So, as a result, we now know more about the government's plans. And the bill now proceeds to its committee stage, where it will be scrutinised on a line by line basis. And the bill committee is due to report to the House of Commons by the 21st of January. Though the exact timetable hasn't been set, we would expect the bill to have completed the parliamentary process by the summer recess, July 2025. Now, the government has stated that it anticipates the majority of these reforms will take effect no earlier than 2026, and that reforms of unfair dismissal will take effect no sooner than autumn 2026. So, also on the 21st of October, 4 separate consultations were published. And in headline terms, these deal with fire and rehire and collective redundancies. Secondly, 0 hours contracts and agency workers. Thirdly, the industrial relations framework. And fourthly, statutory sick pay. Now, those consultations close on the 2nd of December, with the exception of the SSP consultation, which closes on the 4th of December. 23 different impact assessments were also published on the 21st of October, each of them looking at a key measure of the bill and setting out a cost benefit analysis. But it's the economic analysis and the summary impact assessment that's attracted quite a lot of attention this week because it looks at the impact of the bill as a whole and it calculates that the monetized direct cost to businesses of all the planned measures could be as high as £4.5 billion. But to put that in context, that does represent 0.5% of total payroll costs in the UK in 2023. And the government calculates that the direct benefit to workers will be of a corresponding value. It also believes that there will be significant wider benefits to society, including positive impacts on health and well-being, equality, competition, and participation. So let's start looking at some of the details of the key measures and starting with unfair dismissal. So currently, employees must have at least 2 years of continuous service to bring ordinary unfair dismissal claims. This requirement will be repealed and unfair dismissal will become a day one right. The bill refers to an initial period of employment where different rules will apply, but much of the detail of this is still to be worked through. It looks like it will still be possible to dismiss new hires in this initial period as long as the reason for dismissal is fair, that it relates to the employee as an individual, and the employer has followed any process that is set out in regulations. So we don't know the details of what that process looks like at the moment, but it's anticipated that it may involve a meeting with the employee where the employee has the right to be unaccompanied. But the next steps document published by the government with the bill refers to a lighter touch process. And the government has also said it will consult on how this light touch process will interact with the ACAS Code of Practice on disciplinaries and grievances, which currently doesn't refer to probation periods. The length of the initial period will also be consulted on. The government seems to have initially been considering a 6-month period, but its current preference is 9 months. They have said that the right to claim unfair dismissal will not apply where employees haven't started work. So clearly, this is going to be significant and it will be harder for employees to dismiss during the initial period of employment and up to the 2 years than is currently the case. So there will no doubt be a focus for employers on recruitment processes, management during probation, and generally ensuring that procedures are fit for purpose. And the government estimates that an additional 9 million employees will be able to bring claims as a result of this change. One area that may see particular scrutiny is the interplay between these new probationary rules and redundancy. Under the bill at present, redundancy dismissals don't appear to be included in the same lighter touch rules that will govern capability and conduct related dismissals during probation. So this means that potentially employees can still claim unfair dismissal from day one if made redundant without any probationary protection applying. That said, there aren't any proposals to change the eligibility criteria for statutory redundancy payments. The government also intends to consult on what a compensation regime for successful claims during this initial period of employment may look like, and potentially compensation will be lower during this initial period. Protection against automatic unfair dismissal will continue to begin at the point an offer of employment is accepted. So moving on to fire and rehiring and proposals regarding this. So as I'm sure you'll know, this is the practice where an employer, if it's unable to agree changes to its terms and conditions of employment, dismisses its workforce and re-engages them on new and often less favourable terms. And the previous Conservative government introduced a new statutory code of practice to provide guidance for employers on dismissal and re-engagement. Whilst this remains in place for now, the bill is going to bring in new legislation with a strengthened code of practice, and the government has said that its aim is to end this practice. So the bill will create a new category of automatic unfair dismissal, which will create a much stronger disincentive for employers to adopt a fire and rehire strategy. And it will also cover situations for where external workers are brought in as replacement to the existing workforce. Any such dismissals will remain legally valid, but there'll be a much greater risk of liability to pay compensation. And it will also be automatically unfair to dismiss an employee where there's a failure to agree a variation in contract. So this catches situations where an employer is not even planning to offer re-engagement. There will be a defence if the dismissal is required to mitigate severe financial difficulties, but it's not clear what exactly the threshold for that will be. It does appear to be stringent at the moment. Employees can still claim ordinary unfair dismissal if affected by firing and rehiring, and that will be possible even if an automatic unfair dismissal claim fails. So the bill stipulates what a tribunal would consider, i.e., has there been any collective consultation? Has there been anything offered to the employee in return for agreeing a variation? And there may be other matters that will be specified in regulations as well. In the consultation now open, the government is seeking views on whether interim relief should be available for employees bringing unfair dismissal claims on this basis, and that will potentially have a significant impact as well because pay will then be reinstated until a hearing takes place. And the final measure that really affects the dismissal regime relates to collective consultation. So, again, as you'll know, collective consultation applies where employers propose to make 20 or more redundancies at one establishment within a 90-day period. So, the bill removes the reference to one establishment, meaning that employers will be required to collectively consult where 20 or more redundancies are proposed across their whole organisation within a 90-day period. And consultation has opened on this as well. The government is seeking views on an increase to the maximum period of the protected award that a tribunal can make, and they're considering two options. Firstly, whether they increase the protective award from 90 days pay to 180 days pay, or whether they remove the cap on the protective award in its entirety. And again, the government is also seeking views via the consultation whether interim relief should be available to employees who bring claims for the protective award. So, just a reminder, those consultations are open, they close at the start of December. And I'll hand over to my colleague Samantha now to take you through the remainder of the proposed reforms.
Thanks, Fiona. So I'm just going to take you through the measures that have been proposed within the bill regarding both zero-hour contracts and flexible working. So starting off with zero-hour contracts, just to set the scene really, in making these changes, the government have said that they are committed to ending one-sided flexibility and exploitative zero-hour contracts, ensuring that all jobs provide a baseline of security and predictability. So how is the bill proposing to do that in practice? Well, there are three groups of measures that have been proposed to protect zero hours workers. So firstly, and probably the biggest one, 0 hours and low hours workers will have a right to be offered a guaranteed hours contract reflecting the hours that they regularly work over a certain reference period. So with this one, there are unfortunately quite a few aspects of this particular measure which aren't quite clear yet. So we'll need to await further clarification within the regulations. So for example, the reference period itself will be something that will be set out in regulations, although it is anticipated that this will likely be 12 weeks. Also the meaning of regularly working over hours. At present, it's not entirely clear what the trigger will be for when the duty will actually kick in. But in essence, if as an employer you have a large number of low hours workers, you will have to be quite careful in keeping track of how many hours workers are actually working. So their contract might say one thing, but if they're working a certain amount of hours in a week, you might need to make an offer of guaranteed hours and keep that under review. And then we've got the second measure to make you aware of. So the bill requires employers to provide reasonable notice of shifts, including changes and cancellations, to workers on irregular shift patterns or under 0-hour contracts. And again, we do expect that secondary legislation will set out the minimum periods below which notice will be presumed to be unreasonable. And then thirdly, when shifts are cancelled, moved or curtailed at short notice, there will be a right for payment to be made to workers where insufficient notice has been given. And again, we do expect that detailed information regarding the right for payment will be set out in regulations. So hopefully that'll include things like contracts that are going to be in scope, what will constitute short notice, how much the payment will actually be, and any exemptions to that right. And the government have also proposed that these measures will be adapted and applied to agency workers as well. So that is something that is going to form part of a consultation process to determine how exactly that would work in practice. So really, whilst the measures do promise some substantive changes to 0-hour contracts as a whole, there is still a lot of information to be fleshed out in the forthcoming regulations. So one to very much keep a watchful eye on. And then we've got flexible working. So just to put things into perspective and clarify regarding the present position. So as the law stands, employees have a day one right to request flexible working twice a year by applying for a change to their terms and conditions of employment. And employers are currently under duty to deal with a flexible working request in a reasonable manner. So alongside this, an employer can currently only refuse an application on the basis of one of 8 specified business reasons, which are all set out in legislation. So currently, it's very much a subjective test. The employer need only show that they actually consider that one of the business grounds applies. So what the bill proposes to do is to restrict the employer's ability to reject a flexible working request further. So as part of that, the bill imposes an additional reasonableness requirement. So presently, the proposal is that an employer may only refuse a flexible working request if it considers that one of the business reasons apply. So that's the same business reasons that we've got in legislation currently, so no change there. But, and this is the new bit, it also must be reasonable for the employer to refuse the request on that ground. So this would turn what is currently a subjective test into an objective one, with an employer needing to demonstrate that their reliance on the business ground was reasonable. So at the moment, it's a little bit unclear what is going to be considered to be reasonable and what the level of scrutiny will be, if it's intended to be based on a band of reasonable responses or if the tribunal will make the decision itself. So one to watch out for again. And then the second measure within the bill is that it also imposes a duty on the employer, if rejecting a request, to actually explain why. So the employer would need to state the business reason relied upon and explain why they consider it reasonable to have refused the request for that reason. So comparatively, not too many changes to flexible working as we know it, but the position has become more nuanced in terms of actually rejecting requests. And then moving on to a couple of changes that are proposed within equality law. So first off, we've got sexual harassment. So there is an existing duty set to come into effect on the 26th of October, and that requires employers to take reasonable steps to prevent sexual harassment of employees in the course of their employment. This was already quite a significant change. However, the Employment Rights Bill proposes to strengthen this position further. So the duty is going to be changed, that the employer is required to take all reasonable steps, not just reasonable steps. And regulations are expected to follow to really specify the steps which an employer must take and matters to which they must have regard to meet their obligation to take all reasonable steps. Something that I'm sure employers will all be very keen to understand further. And lastly, perhaps not quite as significant, but the bill also inserts that disclosures relating to sexual harassment are to qualify for protection under whistleblowing legislation. And then just a couple of other equality measures to be aware of. So we've got third-party harassment, which is a big one. So the bill prohibits an employer from permitting a third party to harass an employee during the course of their employment, and this is going to be relevant to all protected characteristics. And an employer will be taken to have permitted the harassment if it fails to take all reasonable steps to prevent the third party from doing so. But again, what will amount to a reasonable step in respect of third parties does remain to be seen at the moment. And then secondly, we've got equality action plans. So the bill will require employers which are subject to the gender pay gap reporting, so those that have 250 or more employees, to actually publish an equality action plan alongside that. So these action plans will have to show the steps that employers are taking in relation to their employees with regards to gender equality. And the bill says that the subject matter will be related to gender equality if it's related to advancing equality of opportunity between male and female employees. And that will include things like addressing the gender pay gap and also supporting employees going through the menopause. And then the last one is expected that similar disability and ethnicity pay gap measures will shortly follow in a separate equality, race and disability bill. So again, another aspect to keep your eye on. And then just taking you through the final topics that we'll be covering off today. So firstly, we've got statutory leave. So key measures within the bill include removing the qualifying period for parental leave and paternity leave. So these can be taken by employees from day one of their employment. The bill also introduces the ability to take paternity leave after shared parental leave, and it will also broaden the right of employees to take bereavement leave, although the actual linked relationships to qualify for that bereavement leave will be specified in regulations. And then lastly, quite a significant one, the bill also offers increased protection against dismissal. So currently, pregnant employees have additional protection from redundancy. However, as I'm sure you're aware, redundancy is only one of the 5 potentially fair reasons to dismiss someone. So the bill will amend existing powers that regulations can be made to ban dismissals of employees who are pregnant, on maternity leave and during a 6-month return to work period, except in specific circumstances. So it's no longer confined to just dismissal on the grounds of redundancy. And then just to talk you through statutory sick pay then. So we've got 2 headline points really. So at the moment, SSP kicks in on day 4 of an individual sickness. However, the bill actually removes these waiting days, so employees are to be eligible for SSP on day 1 of their sickness. And then the second point to be aware of is that the bill also removes the lower earnings limit. SSP will now be payable to all eligible employees, regardless of earnings on the first day of their incapacity for work. And they also intend to change the rate of SSP, so that instead of all employees being paid the statutory flat rate of SSP, they would instead either receive the flat rate or a percentage of their weekly earnings, whichever is lower. And the percentage is actually something that's going to be form the subject of a consultation process, which is going on at the moment. And then just to cover off a couple of things that probably were expected to be in the bill, but potentially on the horizon. So we've got the right to switch off. This is something that has been the subject of great debate since it was first proposed by Labour. Again, it's not something specifically contained within the bill, but the government have committed to consulting on a right to switch off and preventing employees from being contacted out of hours, except in exceptional circumstances. And then we've got single worker status. So government have also proposed they will also consult on a simpler 2-part framework for employment status that will help to differentiate between workers and the genuinely self-employed. And then lastly, separate to the changes that we've already gone through relating to parental leave, the government have proposed that they will conduct a full of both the parental leave and carers leave system, including examining the benefits of introducing paid carers leave. So if you thought that the Employment Rights Bill was the end of it, that's very much not the case. And we do still expect a myriad of changes and clarifications to follow. So that brings us to the end then of what we were going to go through today, the topics. So I hope that's been helpful to try to simplify some of the aspects of the Employment Rights Bill. But I can see a couple of questions that have come in, which is great. I've got a little bit of time to go through of them. And then just to clarify that if we're not able to answer all of the questions, we do aim to offer a little bit of a crib sheet afterwards. So that will follow the webinar along with a copy of the slides. So having a look at some of the questions that have come in.
Yes, I can see there's been a couple asked on the unfair dismissal sections of the bill. So if I sort of address some of those. So somebody's asked, how will the statutory probation period work with company probation periods if they are of different lengths? And that's certainly something that you might want to consider over the next couple of years, whether you align your company probation periods with the statutory period, because the statutory regime is always going to overrule what's in the contract. So if the statutory initial period of employment is 9 months and there's a light touch process that you can follow to dismiss in that 9 months, it would be unfair for you to follow that light touch process after the end of the nine-month period, if that doesn't meet sort of the full expectations of the law in relation to a fair dismissal process. So having a longer probation period may not have the same benefits that it now has. And I'm just going to scroll down. So somebody has asked about interim relief. And a little bit more detail about that, what that actually means in practice. So interim relief is a remedy at the moment in whistleblowing cases. It's quite rarely sought, but within 7 days of the effective date of termination or dismissal, and somebody can bring a claim for interim relief in the employment tribunal, and the tribunal will list a hearing as soon as possible, sometimes within a couple of days of receiving the application. And if they believe that the employee's substantive claim is likely to succeed, they can make an award of interim relief. So it's an injunctory remedy, and it reinstates the employee's continuous employment and means that they are then continued to be paid until the issues are all dealt with at a substantive hearing. So it's rarely sought, it's a relatively high threshold, but it involves a lot of work at an early stage and obviously a quite high financial penalty for the employer if it is granted. So as I say, the government is consulting on extending that to fire and rehire. Let me just scroll down. So there's also a couple of questions about 0 hours contracts, or
Yeah.
changes to employment status. And I can see somebody has asked if that will include bank workers. So the answer is that we don't know at the moment because we don't have any proposals from the government on how they might remove the worker category. But bank workers, particularly NHS bank workers, are classified as workers. It's going to be really tricky, I think, for the government to make any changes in that area. And we know that various NHS organisations are reliant on bank workers. So I'm afraid we don't have the answers to that at the moment, and we'll very much have to see what the government proposes to do in that space. But I expect that it would be heavily consulted on.
Yeah, I think quite a few questions on 0 hour workers. I can see one's come in. Will 0 hour workers be obligated to accept guaranteed hours? So in short, no, they won't. The employer will actually have a kind of response period to accept or reject the offer of guaranteed hours. So unfortunately, as Fiona said, there's kind of with the 0 hour contracts, there's still quite a bit to be fleshed out. So that response period isn't clear just yet. So hopefully that will be forthcoming in regulations. But workers that are offered guaranteed hours will be able to remain on 0 hour contracts if they wish to do so. And I think it was part of the next step document that kind of said along the lines of, it's appreciated that 0 hour contracts do work well for some individuals like students or those with caring responsibilities. So, it's not a complete ban of those types of contracts, which will hopefully reassure some individuals and businesses where it does work quite well.
And we've also had a question about the removal of the 2-year length of service period for unfair dismissal and whether this will be the case for colleagues who've already started with the business and are under 2 years length of service. So it will just be for new starters, but also just to remember that these reforms are not due to come into effect until autumn 2026 in any event. So if you have any sort of new starters at this point, then they'll be reaching the 2-year period by then anyway. But there will be a date, from which these provisions are effective. And a further question, are there any figures on the likely number of additional tribunal claims from unfair dismissal being a day one right? And are there any planned changes to the tribunal system to cope? Which is a really good question. So the government has estimated that there'll be 9,000 additional employees who could potentially claim unfair dismissal. How how that translates into actual claim numbers, we don't know. They have paid some lip service to the impact that they will have on the employment tribunal system. But I would expect that for very many employers, that will be something that you'll be wanting to feed back during consultation, that the tribunal system will need additional resource. Um, to manage these claims. Oh, and one thing the government has also said is that they will be providing information and resources about this initial period of employment and providing guidance as to when claims are misconceived. So we'll wait and see what that looks like.
I can just see a question come through about the sexual harassment bits that are going to come through. So what's likely to be meant by taking all reasonable steps to prevent sexual harassment? So this one might be slightly difficult to answer at this stage, because we are again expecting regulations to flesh out a little bit more what's going to be reasonable, and hopefully that's going to include things like clear steps an employer would need to demonstrate, and hopefully alongside a bit of a list of potential steps that they could take. But I think at this stage I'd probably expect the list to cover things like undertaking risk assessments, making sure that your policies are up to scratch, ensuring that you're taking steps to handle complaints that come in and reporting of sexual harassment. So I think just trying to be as proactive as possible and taking early intervention where you can would be the best way. But as I say, hopefully regulations will flesh it out a little bit more.
Yeah, I can see there's a few questions as well about when this is all going to take effect. So just to reiterate, the government, is starting consultation on some of the measures now. It envisages consulting for the next year. It'll be July, we think, until the parliamentary process is completed on this bill. So we don't expect any reforms to take effect before 2026. And the unfair dismissal changes, the government has said it will be autumn 2026. So there's a specific question here on the statutory sick pay, reducing down to day one. And as I said, the indications are that is going to be 2026 before that takes effect. I think for all the other questions now, what we'll try and do is a bit of a roundup after, and email with answers to those. And I think people are sort of noting in the comments that there's the devil's in the detail, and there's still much to be worked through. So if you bear with us, we will endeavour to answer all the questions and circulate those to you as well. The session has been recorded, so you'll receive a copy of that together with the slides. Thank you very much for attending today. We hope it's been helpful. And just a reminder, please, that when the session closes, there should be a pop-up to a feedback survey. So please do pop your thoughts in there. That would be really helpful. But thank you for your time, and have a great day.
Thank you.